What happens to your pension when you divorce? Now, it depends on how your divorce agreement is worded. Hi, I'm Simon Dippenaar and I'm a family lawyer. Our pension sharing on divorce is a fairly well understood concept, as the clean break principle has been around since 2007. Now, when it comes to retirement savings, the fund must pay the non-member spouse an agreed percentage of the member spouse's so-called pension interest. In other words, the value of the accumulated savings, if required to do so by a court of order, calculated to the day of the divorce. Now, however, the law is very specific about the wording that describes the settlement. A case that recently came before the pension fund's adjudicator shows how important it is for the wording about the retirement fund asset split to be correct in the divorce agreement. A woman was left without the money she was expecting from her ex-husband's retirement fund on his death when the Financial Services Tribunal upheld the decision by the pension fund's adjudicator. The ex-wife complained to the adjudicator that her ex-husband's retirement annuity fund had not acted in accordance with the divorce agreement. Rather, the death benefit of her ex-husband's pension was paid to his second wife. The couple divorced in 2009 after 29 years of marriage. Although the clean break principle came into effect in 2007, it seems the lawyer who drew up the divorce agreement was unaware of it. Without going into detail of the wording in this short talk, the agreement got two things wrong. Number one, it breached the clean break principle, which was already in force, by entitling the ex-wife to benefits at date of maturity of the retirement annuity instead of at the date of divorce. This was unenforceable under the Pension Funds Act, which requires a fund to make deductions from pension benefits on receipt of a divorce order. In other words, the ex-wife should have received her share of the pension interest 10 years before the date of maturity. Number two, more critically, the agreement did not name the fund, which absolved it of responsibility. This may all seem unfair to the ex-wife, but is entirely within the law. She may want to take the issue up with the attorney who drew up the divorce agreement. So what's the moral of the story here? If you're going through a divorce, make sure the settlement order is correctly worded. In short, there are 4 conditions that must be fulfilled before pension assets may be split. They are: number 1, the divorce order must state clearly that the spouse who is not a member of the fund is entitled to a share of the pension interest as defined in the Divorce Act. Number 2, the divorce order must specify the non-member spouse's share of this pension interest, either as a percentage or in rands. Number 3, the fund that has to deduct the share of the pension interest must be named. Number 4, and the fund must be ordered to endorse its records and pay the share of the pension interest. The matrimonial regime has a bearing on the settlement. If you are married in community of property, the split is automatically 50-50. However, if you are married out of community of property with the accrual, the split may be different. If you are married out of community of property without accrual, you each walk away with only your own assets, and pension sharing is not relevant. If you want to discuss pension sharing or any other aspect of dividing your assets on divorce, or if you are getting married and wondering about the best matrimonial regime for you, give me a call in strict confidence on 086 099 5146.